Welcome to r/red. This story originally took place back in 2014. Understandably so, it caused a media frenzy. It has started circulating the internet once more, so in this video we will be going over all the original news articles. We will start with a 2017 NBC News post by Jay Schweikert. He does an amazing job at giving a clear overview of this story. He also includes external links to court documents and other relevant information. His original story link and the court document links will be in the description below. Article 1. A teen sexting case revealed how judges let police invade children's privacy. By Jay Schweikert.
A teen sexting case revealed how judges let police invade children's privacy. Whether the police have the right to force your teenage son to masturbate in front of them in order to incriminate himself is a legal question few parents would think they'd have to consider. And yet Trey Sims' legal guardians had to do exactly that. In an effort to prosecute the 17-year-old for sexting his 15-year-old girlfriend, Manassas police detective, David Abbott, obtained a search warrant authorizing him to take photographs of Sims' genitals, including a photograph of the suspect's erect penis. According to court documents, in the process of executing the search warrant, Abbott took the teenager to a juvenile detention center, took him to a locker room and, with two uniformed, armed officers looking on, ordered Sims to pull down his pants. After taking pictures with his cell phone of the teenager's genitals, Abbott then ordered the minor to masturbate so that he could take a picture of his erection. Sims tried but failed to comply with the officer's orders. Abbott later threatened Sims' lawyer that, if police couldn't get a picture of the teenager's erection by forcing the kid to masturbate, he would obtain a photo of the teenager's engorged genitals by subjecting him to an erection-producing injection at a hospital. The facts of this case are outrageous, but sadly, they're not the product of any single bad actor or law. On the contrary, they reflect a criminal justice system that's structurally broken at almost every level. And the only reason that police never obtained the pictures they demanded under court order from Sims was that there was a massive public outcry after news reports emerged about the case in 2014, and the police let the search warrant expire. Sims, however, continued to face felony charges for sexting his girlfriend, eventually living under probation for a year before the courts dismissed those charges. It wasn't until this month, more than 3 years after Sims was taken to that locker room, that a federal appeals court issued a decision in his favor. By a divided 2-1 vote, the court held that a reasonable police officer should have known it was unlawful to order a teenage boy to masturbate in front of him and other officers. Notably, though, that meant that one judge felt that police should, indeed, have the right to force children to masturbate in front of them in order to incriminate themselves. First and foremost, the fact that Sims' initial conduct was criminalized at all speaks to the staggering breadth of substantive overcriminalization. The activity for which Sims was charged was a consensual, mutual exchange of nude pictures and videos between two teenagers in a lawful relationship. In Virginia, it's legal for a 17-year-old and 15-year-old to have sex. Sexting between teenagers is commonplace, and often an innocuous part of flirtation and sexual expression in the digital age. If the taking of or delivery of pictures were non-consensual, or if one party was of the age of majority, that would be a legal issue to address. For parents, such behavior might well be concerning, if not deserving of some proportionate punishment. But to brand Sims a child pornographer under Virginia law is to say that a teenager's consensual, mostly, non-harmful conduct merits one of our society's most severe punishments and social stigmas. The criminal law is a blunt instrument and incarceration is an extreme remedy. Both are poorly equipped to address nuanced social problems and should be a last resort for the most dangerous antisocial behavior. Instead, they've become the reflexive default for any behavior that certain segments of society find problematic. And the legislative predilection for criminalization is compounded by the judiciary's failure to insist that the government offer any justification for putting someone behind bars. In the vast majority of cases, the state doesn't have to show that criminalization serves any legitimate interest, and the defendant is not even permitted to introduce evidence to the contrary. Further, the obscene invasion of Sims' privacy shows just how permissive courts are in letting cops search you almost anywhere, in any manner, and for any reason. Even when police have unlawful motives for stopping you, like racial discrimination, a detention is still legally permissible so long as there's probable cause for something, including minor traffic violations. Alerts from drug-sniffing dogs, i.e., probable cause-creating dogs, are nearly always enough for a search, even if such alerts are barely more reliable than a coin flip. And before admitting you to jail, state officials may conduct an invasive strip search, no matter what you were arrested for, even traffic offenses, and regardless of whether there's any reason to suspect you have contraband. So it's outrageous but ultimately unsurprising that the judicial system's cavalier disregard for personal privacy, as guaranteed by the U.S. Constitution, has led us to the point that a judge can authorize and police will execute a search that effectively amounts to the sexual assault of a teenager. Whatever the supposed harm of Sims' underlying behavior, there is no doubt that a police officer forcing a teenager to masturbate in front of armed adults under threat of a frightening medical procedure is vastly worse than a teenager consensually sexting his girlfriend. And the difficulty that Sims has faced in vindicating his constitutional rights shows how police operate with almost no accountability for their actions. Following his ordeal, Sims filed a civil rights lawsuit against Abbott, arguing that his search violated his right of privacy under the Fourth Amendment. Incredibly, the district court dismissed Sims' complaint, finding that the detective was entitled to qualified immunity for his actions. In other words, even assuming that ordering a teenager to masturbate in front of the police was unlawful, the law was not clearly established enough for Abbott to know for sure that it was unlawful. In qualified immunity doctrine, clearly established law usually requires not just a clear legal rule, but a prior case with functionally similar facts. The perverse result of this standard is that police will get immunity in the most egregious cases, precisely for the reason that the most extreme kind of misconduct is less likely to have occurred in the past. The Fourth Circuit did reverse this dismissal and permit Sims' case to proceed, but even that was a close call. The panel decision was 2-1. The argument made in the dissent, had it been accepted by one other judge, would have granted Abbott total immunity, going so far as to say that Abbott's actions were lawful. Sims' case shows that we have a system in which the legislative branch is permitted to criminalize whatever it wants, with effectively no judicial oversight. Police investigations are invasive, unchecked, and can cause far greater harm than the underlying criminal act, and it is nearly impossible to hold police liable for unlawful misconduct. Until we address those systemic problems, we should expect more tragic cases like this one.
We are at the end of the story overview. Now let's dig a little deeper by reviewing the news articles that were released as this case was taking place. You will quickly realize the police department tried to cover up the fact the 17-year-old boy was forced to masturbate in front of 3 officers in an attempt to take a photo of his erect penis. Article 2. In sexting case, Manassas City Police want to photograph teen in sexually explicit manner, lawyers say. The original 2014 news report by Tom Jackman. A Manassas City teenager accused of sexting a video to his girlfriend is now facing a search warrant in which Manassas City Police and Prince William County prosecutors want to take a photo of his erect penis, possibly forcing the teen to become erect by taking him to a hospital and giving him an injection, the teen's lawyers said. A Prince William County judge allowed the 17-year-old to leave the area without the warrant being served or the pictures being taken, yet. The teen is facing 2 felony charges, for possession of child pornography and manufacturing child pornography, which could lead not only to incarceration until he's 21, but inclusion on the state sex offender database for, possibly, the rest of his life. David Culver of NBC Washington first reported the story and interviewed the teen's guardian, his aunt, who was shocked at the lengths Prince William authorities were willing to go to make a sexting case in juvenile court. The prosecutor's job is to seek justice, said the teen's defense lawyer, Jessica Harbison Foster. What is just about this? How does this advance the interest of the Commonwealth? This is a 17-year-old who goes to school every day, plays football, has never been in trouble with the law before. Now he's saddled with 2 felonies and the implication that he's a sexual predator. I don't mind trying the case. My goal is to stop the search warrant. I don't want him to go through that. Taking him down to the hospital so he can get an erection in front of all those cops, that's traumatizing. Manassas City Police spokeswoman Adrienne Helms said the department would not comment, and Detective David E. Abbott, the lead investigator on the case, did not return a call seeking comment. And no one except a Prince William magistrate has seen the affidavit and search warrant for the photos. They aren't made public until after they are served and then returned to the courthouse. The Post is not naming the teen defendant. Foster said the case began when the teen's 15-year-old girlfriend sent photos of herself to the 17-year-old, who in turn sent her the video in question. The girl has not been charged, and her mother filed a complaint about the boy's video, Foster said. The male teen was served with petitions from juvenile court in early February, and not arrested, but when the case went to trial in juvenile court in June, Foster said prosecutors forgot to certify that the teen was a juvenile. The case was dismissed, but the police immediately obtained new charges and also a search warrant for his home. Police also arrested the teen and took him to juvenile jail, where Foster said they took photos of the teen's genitals against his will. The case was set for trial on July 1, where Foster said Assistant Commonwealth's Attorney Claiborne Richardson told her that her client must either plead guilty or police would obtain another search warrant for pictures of his erect penis, for comparison to the evidence from the teen's cell phone. Foster asked how that would be accomplished and was told that, "We just take him down to the hospital, give him a shot, and then take the pictures that we need." The teen declined to plead guilty. Foster said the prosecutor then requested a continuance so police could get a search warrant, which was granted by substitute juvenile court judge Jan Rolshenol. 2 days later, both sides were back in court. Foster had filed a motion to allow her client to travel out of state to visit family. Richardson wanted the teen to comply with a search warrant before he left. Juvenile court judge Lisa Baird declined to order that, and allowed the teen to leave the area. But he has another court date on July 15. Despite the request by the prosecutor in court, Prince William County Commonwealth's attorney Paul B. Ebert said that police told him these allegations by the lawyers lack credibility. He said he would look into the matter further. Carlos Flores Laboy, appointed the teen's guardian ad litem in the case, said he thought it was just as illegal for the Manassas City Police to create their own child pornography as to investigate the teen for it. They're using a statute that was designed to protect children from being exploited in a sexual manner, Flores Laboy said, to take a picture of this young man in a sexually explicit manner. The irony is incredible. The Guardian added, "As a parent myself, I was floored. It's child abuse. We're wasting thousands of dollars and resources and man-hours on a sexting case. That's what we're doing." Foster said Detective Abbott told her that after obtaining photos of the teen's erect penis he would use special software to compare pictures of this penis to this penis. Who does this? It's just crazy. In response to Tom Jackman's story Wednesday morning about a felony sexting case in Prince William County, the Manassas City Police released this statement shortly after 6 p.m. Wednesday night. Article 3. Manassas City Police release statement on teen sexting case. By Tom Jackman. For immediate release. Juvenile sexting case. On January 23, 2014, Manassas City Police was contacted by a parent of a 15-year-old female juvenile who was sent pornographic videos by a 17-year-old male suspect after repeatedly being told to stop. Upon further investigating the incident, charges of manufacturing and distributing child pornography were brought against the 17-year-old male suspect on January 28, 2014, after consultation with the Commonwealth Attorney's Office. The matter was set for trial on June 4, 2014, where charges were nolli prosequi by a Prince William County Assistant Commonwealth Attorney. The circumstances on the decision to dismiss charges and bring forward new charges cannot be released at this time due to this incident being an active investigation and involving juveniles. New charges of manufacturing and distributing child pornography have been brought forward and a court date is pending. It is not the policy of the Manassas City Police or the Commonwealth Attorney's Office to authorize invasive search procedures of suspects in cases of this nature, and no such procedures have been conducted in this case. Beyond that, neither the police department nor the Commonwealth's Attorney's Office discusses evidentiary matters prior to court hearings. The day after Tom Jackman released his story in the Washington Post and the Manassas City Police released their own statement, the Manassas City Police decided they would not pursue the search warrant that included pictures of his erect penis on the teenage boy. Once again, we will be reviewing Tom Jackman's article. Article 4. Manassas City Police say they will not serve search warrant in teen sexting case. By Tom Jackman. Manassas City Police said Thursday they would not serve a search warrant seeking to take photos of a 17-year-old boy charged with sexting an explicit video to his 15-year-old girlfriend earlier this year. The teen is facing felony counts of manufacturing and distributing child pornography. As the case was headed to trial last week, Manassas City Police and Prince William County prosecutors said in juvenile court that they had obtained a warrant to photograph the teen's erect penis, in order to compare with the video he allegedly sent in January, according to the teen's lawyers. When defense lawyer Jessica Harbison Foster asked how they would obtain a photo of her client while aroused, she said police told her they would take him to a hospital and inject him with a drug to force an erection. On Thursday, Prince William authorities decided to drop that plan. Lieutenant Brian Larkin of the Manassas City Police said, "We are not going to pursue it." He said the police planned to allow the search warrant, obtained last week, to expire. He would not say why the decision had been made to abandon the warrant or discuss the reasons for the search. Larkin referred further questions to Prince William Commonwealth's attorney Paul B. Ebert. Ebert did not immediately return a call seeking comment. Foster was not immediately available for comment. I am floored by this story. I am curious to know how the teenage girl's parents felt after finding out about the traumatizing events the teenage boy was put through. Were they okay with it? Or did they feel guilty? Post your thoughts below in the comment section and don't forget to like, subscribe, and hit the notification bell for part 2 of this story.